Here's a decision that's about to reshape millions of American careers, and you probably haven't heard about it yet. The Federal Trade Commission under Trump's leadership has just pulled the plug on defending what could have been the most worker-friendly employment rule in decades. In a stunning reversal, the agency is abandoning its legal fight to uphold a comprehensive prohibition on non-compete clauses that trap employees in their current positions. Here's where it gets controversial. This isn't just about legal technicalities. We're talking about the economic freedom of roughly 20% of America's workforce. Through voluntary dismissal motions submitted this past Friday to 2 different federal appeals courts, the FTC has effectively buried the Biden administration's ambitious attempt to eliminate these restrictive employment contracts. This dramatic policy U-turn represents yet another example of how Republican FTC leadership is systematically dismantling the regulatory framework established by their Democratic predecessors. Let's break down what actually happened here. Back in 2024, during the Biden era, the FTC implemented this groundbreaking non-compete regulation, which immediately sparked fierce legal opposition. The rule faced its biggest challenge when a federal district court in Texas completely invalidated it on a national scale, a decision that sent shockwaves through both corporate boardrooms and worker advocacy groups. The proposed regulation would have essentially eliminated the vast majority of non-compete clauses, those notorious contract provisions that severely limit employees' ability to switch jobs within their own industry. Think about this for a moment. According to the FTC's own research, approximately 1 out of every 5 American workers currently operates under these restrictive agreements. That's millions of people whose career mobility has been artificially constrained. Andrew Ferguson, who now chairs the FTC and was serving as a Republican commissioner when the original vote took place, strongly opposed the measure from the beginning. His argument? The regulation completely overstepped the FTC's congressionally granted authority to create such sweeping rules. The business community rallied behind this perspective. The influential U.S. Chamber of Commerce, partnering with Ryan LLC, a prominent Texas-based tax services firm, launched a comprehensive legal challenge echoing Ferguson's constitutional concerns. Their efforts paid off when Judge Ada Brown of the U.S. District Court for the Northern District of Texas sided with their arguments last August, striking down the entire rule nationwide. Interestingly, the Supreme Court had already begun limiting judges' authority to issue such broad nationwide injunctions in a June decision, adding another layer of complexity to this legal landscape. Despite these setbacks, the FTC under previous leadership wasn't ready to surrender. This past January, they filed appeals with both the U.S. Court of Appeals for the Fifth Circuit and the 11th Circuit. The Fifth Circuit appeal challenged the Texas court's decision directly, while the 11th Circuit case addressed a separate ruling that questioned whether the FTC possessed clear congressional authorization to implement such regulations under the Supreme Court's Major Questions Doctrine. Former FTC Chair Lina Khan had passionately defended the non-compete prohibition, arguing it fell perfectly within the agency's core mission to eliminate unfair competitive practices. When announcing the rule's adoption, Khan highlighted the overwhelming public support it received, more than 25,000 public comments favoring the regulation. She emphasized how these restrictive agreements don't just limit economic opportunities, but create a ripple effect that robs people of their economic liberty and all sorts of other freedoms, chilling speech, infringing on religious practice, and impeding people's right to organize. And this is the part most people miss. This FTC policy reversal isn't happening in isolation. Just recently, on July 8th, the 8th Circuit Court of Appeals struck down another consumer-friendly regulation, requiring businesses to simplify the cancellation process for recurring memberships. This pattern suggests a broader systematic dismantling of regulatory protections that were championed during Khan's tenure. So here's the million-dollar question that's dividing economists, labor advocates, and business leaders. Are non-compete agreements essential tools for protecting legitimate business interests and encouraging innovation through trade secret protection? Or are they simply corporate weapons designed to suppress wages and limit worker freedom in today's economy? The legal cases at the center of this controversy are Ryan versus FTC, Fifth Circuit, 24-10951, 9525, and Properties of the Villages versus FTC, 11th Circuit, 24-13102, 9525. Decisions that will likely influence employment law for generations to come. What's your take on this? Do you believe workers should have unrestricted freedom to move between competitors? Or do companies deserve protection for their investments in employee training and proprietary information? This debate touches every industry and every career level, and the outcome could fundamentally change how Americans think about job mobility and economic opportunity.